Next case to come before the court is Giant, Ohio versus Jabbar. We're just about 3 or 4 minutes early. Do you have anyone that needs to yet? Are you waiting for?
I think we're ready to proceed if
We're
anybody
ready.
is.
We're definitely ready to interview. We're ready to proceed.
All right, thank you, Your Honor.
And I'm sure I didn't pronounce the last name right.
The appellant's last name is Jaber.
Jacob. I almost said that, but it couldn't be that. You have 15 minutes. You may reserve up to 5 if you so desire. Just let me know.
Thank you, Your Honor. May it please the court, counsel Andrew Whitus on behalf of Mahmoud Jaber, the appellant in this matter. Your Honors, the case before the court today is a breach of contract case that arises from a business deal between 2 cousins, Mr. Jaber and his cousin, who is the president of Giant, Ohio, for some gas to be produced to a gas service station. It's a deal that quickly goes south. Litigation ensues, as the court knows from the briefs. And on April 14th of 2015, the court, on a motion for summary judgment, assesses both contractual liability as well as damages in the amount of $135,000, $422.20 against Mr. Jaber. The issue before the court is one-fold, and that issue is whether the common pleas court erred in assessing damages on summary judgment against Mr. Jaber without the actual full evidentiary hearing. We submit that that was error, that a hearing should have been held to assess those damages properly against Mr. Jaber. We know from the Textron case in this district the proper measure for summary judgment damages in contracts cases. We also know from Textron that damages in contract cases typically require a higher level of proof or higher evidentiary proof than other cases before trial court. Furthermore, in the Baxter case from the 5th District, we know that when damages issues before the court as it relates to summary judgment, that a trial court should, the court suggested a trial court should hold an evidentiary hearing assessing the proper damages. In this case, all we have is an affidavit from Ms. Whitaker, who is the property manager or property administrator for Giant, Ohio, suggesting that the damages to be assessed against Mr. Jaber are $135,422.20. That number is important because that is the exact figure that the court adopts in its April 14th, 2015 order and assesses against Mr. Jaber. As we look at that affidavit, we notice that $31,000 plus is for gas that was already delivered to the service station for non-payment of that. $67,000 plus is for debranding and rebranding costs alleged through this affidavit for this service station, and $36,000 plus in liquidated damages for loss of product sales. Now we take particular issue with the final two, the $67,000 for the debranding and rebranding costs as well as the liquidated damages. We would submit that the case law that's outlined in our brief is clear as it relates to liquidated damages and the necessary causation element between the actual breach of contract, in this case Mr. Jaber's breach, and those liquidated damages. We find that, or we would submit that there isn't sufficient evidence in that affidavit to dispel of any genuine issue of material facts relative to the summary judgment on the damages issue. Furthermore, the $67,000 plus as it relates to the debranding and rebranding also includes some costs that were in an ancillary contract between the appellee and a third party. Mr. Jaber never had an opportunity to challenge any of that evidence as it relates to damages at the trial court level. Now, at this point, I think procedure is particularly important for the court to consider. We know that in this case, on 4/14 of 2015, the trial court assesses damages on the summary judgment motion against Mr. Jaber. There was a response filed prior to that by Mr. Jaber's trial counsel. Thereafter, on 5/1, the court holds a telephonic status conference wherein it gives Mr. Jaber leave to file What it suggests is a motion regarding those damages. That was issued on 5/4. On 5/15, Mr. Jaber's counsel files a motion on those damages, makes arguments rebutting the arguments in the affidavit regarding damages from Whitaker, and also submits a contradicting or a controverting affidavit regarding those damages. So now at this point, and it's important to note that an oral hearing, an evidentiary hearing, was also requested by counsel on 5/15. So at this point, we have a request for a hearing, we have a rebuttal on the damages that were assessed against him already, and we have an affidavit directly from Mr. Jaber, the defendant, regarding the damages assessed against him. Thereafter, on 6/12, the court again issues what in this case was the final and appealable order, suggesting that the language in their 414 order regarding damages is accepted. They dispel of all arguments made in this motion regarding damages by Mr. Jaber and the supporting affidavit as a reconsideration motion for summary judgment. Now, it's puzzling to me that on 5/15, or on 5/4 rather, the court says, Mr. Jaber, you can address damages, and then right after that, as he addresses damages on 6/12, the court says, we are going to adopt the exact language of our 414 order on damages. Mr. Jaber never had an opportunity in this case to argue damages, and that's why we're here. Which brings me to my second and final point, that the failure to hold a full evidentiary hearing after this procedural issue occurred and after the motion for damages was submitted was error, and reversible error. If we look at the Hall case from the 2nd District, we see that when we have conflicting written statements, written evidence regarding damages on summary judgment, that the Hall court, the 2nd District, suggests that it's reversible error when a court does not hold a full evidentiary hearing to assess the proper amount of damages based on the contractual proof that we know that we need in Textron, Baxter, and its progeny. Therefore, at this time, the appellant submits to the court that this case be reversed and remanded to the trial court for a full evidentiary hearing on the issue of damages only. Thank you.
Thank you, Counsel.
Good morning.
Good morning.
May it please the court, my name is Greg O'Connor. I represent the plaintiff, Giant, Ohio. I have to admit I'm a little bit baffled as to how the argument can be made to this court that Mr. Jaber didn't have the opportunity to argue damages. As the briefs, my brief in particular, lays out, my motion for summary judgment was filed, and his opposition memorandum was not filed until more than a year later. When he did file his opposition memorandum, he chose to make no arguments regarding damages. His sole argument was with respect to liability, and that was simply a statement that he didn't think he should be liable because he was helping his son when he signed this contract. It wasn't until he lost on summary judgment that he thought that's a problem and submitted a new motion, which was in reality a motion for reconsideration. I don't think there's any doubt that that's what it was. The April 2015 decision from the trial court was a final decision on his summary judgment.
Well, I'm getting a little confused as to that, and obviously we'll pick this apart.
Sure.
But the decision was a decision on the summary judgment as to these two parties, but there was a third party involved.
Lancaster, yes.
And nothing was resolved with that. That was still pending.
Correct.
So this was not a final judgment that was not subject to reconsideration, though, was it?
It was, because
Why?
I think in this court's decision in Vinylux, it resolved that exact issue. Because it resolved everything as regards in between Giant and Mr. Jaber, everything between those two. It only didn't resolve something with respect to Jaber and Lancaster. It was a final order. It wasn't a final appealable order, as this court said in response to my motion to dismiss, but it was a final order. And what Vinylux says
I'm
is...
only smiling because we just had a huge, big discussion in Columbus over all this.
Over this, yeah.
The Judges Association.
When it rains, it pours. It comes in
When
waves.
people say final and appealable, and it just makes me smile.
So,
I understand there's case law
yeah.
on this issue, but...
and I think it makes sense. I mean, that decision addressed liability and damages. It was a final decision with respect to all of the claims between these
The two
parties.
parties.
To suggest
So the
then,
fact that there was no 54B language was irrelevant.
well, it was irrelevant to whether it was a final order. It was relevant, I guess, to whether it could have been appealed.
Appealed.
Yeah, it could have been appealed at that point. And then, I mean, if you look at what happened, it was that he saw, hey, I lost on summary judgment, I better do something here, and he submits his motion for reconsideration, and the affidavit attached to that is no better. For the first time, it requests the hearing, first of all. I think the hearing is a red herring here. There's no requirement for a hearing. It's entirely within the trial court's discretion, and the case law in my brief pretty amply lays that out, I think. He didn't request one until the reconsideration anyway, and it wouldn't have mattered. This was, even if you look at his affidavit on reconsideration, it was an entirely one-sided summary judgment. The evidence I provided on behalf of the summary judgment from Ms. Whitaker, documented to a T, tied to contract provisions. I think I said in my brief, it's difficult to conceive of a more properly supported summary judgment motion. It's no coincidence, as Mr. White says, that the figure set forth in Ms. Whitaker's affidavit and detailed with the documents attached to it was adopted exactly by the trial court. That's not a coincidence. It's because that was the evidence that the trial court had. In his opposition memorandum, his reconsideration affidavit didn't raise anything remotely approaching a genuine issue of material fact. He blamed the BP oil spill, and he said basically, and you guys obviously can read this, he said basically, I dispute the liquidated damages and the debranding and rebranding costs. Those damages were detailed in the motion, in Ms. Whitaker's affidavit, in the documents attached to Ms. Whitaker's affidavit. It's not, the liquidated damages were not a penalty in any respect. They were the exact amount of money that Giant would have received had Mr. Jaber purchased the 50,000 gallons of minimum gasoline per month as the contract required him to do. That's all they would have gotten. That's all the liquid damages they got. I think the Lehrer decision I mentioned in my brief is important here for that reason too. Mr. Jaber had 18 months almost, by my count, to present the court with anything he wanted to present with respect to damages. He could have done depositions. He could have submitted interrogatories. He could have submitted document requests. He could have provided documents of his own. He could have provided any facts to support his dispute, general dispute, that he didn't want to be liable, or he didn't think Giant should get the money they're requesting, but he chose to do none of that in 18 months. And that Lehrer decision says exactly that. If it's that one-sided, you lost the opportunity. He had opportunity after opportunity after opportunity. So the argument here on appeal that he didn't have the opportunity and that there should be a hearing is nothing more than a second bite at the apple. So unless there's any questions, I'll yield the rest of my time and ask that the decision be affirmed.
Thank you, Counsel.
Thank you.
Your Honor, did I reserve any time for rebuttal? I think I meant to.
That's okay, you have time.
Thank you. A few things that I want to address with respect to Mr. O'Connor's argument here. The first is the timing issue with regard to Mr. Jaber's trial counsel's response to the motion for summary judgment. There was a third party involved, as the court pointed out. That third party was Lancaster Oil. Lancaster had filed a bankruptcy petition in the United States Bankruptcy Court. In this case, I believe, was placed on a bankruptcy stay, and that's why the time frame between the summary judgment motion and the responsive motion for Mr. Jaber was such a long period of time, because this case was essentially stayed due to the bankruptcy proceedings. So in no way was it dilatory conduct on Mr. Jaber's part. It was simply complying with the court's order regarding the bankruptcy stay of the third party Lancaster. Secondly, as it relates to the final and appealable order language, this court disposed of that as it relates to Mr. O'Connor's motion to dismiss. The 414 order had no 54B language in it. The 612 order did. So I think that's a non-issue before the court.
Well, it may or may not be, but But the point of the matter is, counsel on the other side reminded me, again, whether I necessarily agree or not, that there's prior precedents from this court in Vinylux in regard to the motion for reconsideration.
And I think the semantics used by the court below in our case is important here to address that issue, Your Honor. In Vinylux, it was a motion for reconsideration. The party there was trying to take another bite of the apple, as Mr. O'Connor pointed out. In our case, we have an order assessing damages on April 14th of 2015. That's very important. Mr. Jaber had at that point not submitted any or had the opportunity provided by the court to submit damages arguments at that point. Then on 5/1 in this telephone conference, he was specifically granted in the court's order, which is in the record, leave to file what they classify as a motion regarding damages. He files that on 5/15 as a motion regarding damages, makes damages arguments, requests a full evidentiary hearing, and then on 6/12 the court says, oh wait, that's a motion for reconsideration. That's where the error is here. The court pulls the rug out from Mr. Jaber on the damages issue. They purport to allow him to address the damages issue, and then they take it away almost immediately thereafter once he does address it. So again, we submit that the issue regarding damages assessing it's Mr. Jaber in this matter needs to be reversed, remanded, sent back down to the trial court for a full evidentiary hearing on the summary judgment damages, as there still remains a genuine issue of material fact as it relates to the assessment of damages.
Thank you.
Thank you.
Thank you, counsel. For both of your arguments to the court will take the matter under advisement and issue a written opinion that will be sent to both sides as well as released on our website.
Thank you, Your Honor.